Good morning, everyone. Thank you all for joining me this morning. It's still morning, right? Well, it's morning by me, so good morning, everyone. I'm going to go ahead and share my screen, and we can go ahead and get started with our presentation. Here we are. All right, so what are we discussing today? We're going to be discussing what you need to know about the removal of conditions. Now, this is the marriage-based removal of conditions. This should not be confused with the removal of conditions required through the EB-5 investment employment category. This is for those who get their green cards based off of marriage. In some instances, we'll get a conditional green card instead of a full 10-year green card. Who are we? Alcorn Immigration Law, and what we do, we overcome borders, expand opportunity, and connect the world by practicing compassionate, cutting-edge, and rigorous immigration law in the service of the betterment of humanity. We really strive on putting ourselves into our clients' shoes and making them feel comfortable, confident, and satisfied with working with a legal group like ours. This is me. I'm Anita Koumriqian. I'm one of the partners here. As Edith mentioned, I'm a proud Santa Clara alum. Santa Clara Law School, that's where I went to law school, as well as a Bruin. I went to UCLA for my undergrad. I have experience in both family-based immigration, as well. I'm an expert in family-based immigration, so these types of cases, as well as some family law. Which really supports me and helps me with some of my family-based cases, because sometimes people go through divorce and we need to know the ins and outs, the tips, the tricks about divorce and just how it impacts your immigration status. As a proud immigrant myself, I love doing what I do. I was born in Iraq, moved to the States when I was 5 years old. Ethnically, I am Armenian, and I'm not born in the U.S., but I was raised in the U.S., so I'm a very, very proud American, which leads me to supporting my clients in living their American dreams as well. See, I told you, I came here with my green card when I was 5 years old. Here I am down here. That's my older sister, but here I am down here. This is our green cards. This is not a conditional green card. This is a full 10-year green card. Actually, oh yeah, my green card did expire at some point. But as you can see, my green card was pink, which I think is adorable because I was a little girl when I came, but little boys don't get blue green cards. That has changed. Green cards have like a greenish hue, but they're kind of colorful, which is odd. I don't know why they even call it a green card. But anyways, this is our team. This is the group of wonderful individuals that support our team in supporting our clients live their American dream. All of the people that you see on the screen here, they're either immigrants themselves, married to an immigrant, the children of immigrants. So we get it. We've been there before, or our family members have been there before, our loved ones have been there before. This is our wonderful network. We're supported by people in this network. We support those in these networks, so we're proud of it. Immigration law overview. So what is the typical immigration path? Now, immigration has two main tracks, in that somebody can either enter the United States with a temporary visa and then eventually graduate to having a green card, and then eventually have that final step of becoming a full-fledged United States citizen. Or there's people like me, for example. When I entered the United States, I came straight away with that pink green card. And then from there, my family and we applied for U.S. citizenship. So there's two pathways, there's two tracks. Both of them are unique and doable in their own ways. Immigration during COVID. Has it been an interesting past year? I really live by the quote of, there has never been a dull moment in my career, but man, there's been like not even the slightest bit of a dull moment in the past year. We have really been tested and tried. The entire immigrant community, of course the entire world with a global pandemic, but the immigrant community, man, I feel like we couldn't catch a break. But there's just been some delays with biometrics and appointments and just overall delays, and backlogs that we're hopeful that will slowly and not slowly, hopefully quickly come to an end. So there's just been delays in biometrics, even in receipt notices being sent out, but ultimately cases are not really being scheduled for interview, which means cases are not being adjudicated. So people are kind of left in that pending gray area for a while, which is frustrating for our clients because they want to move on with their lives. USCIS has adopted and started to allow attorneys to appear telephonically to interviews. So we've had the ability to appear telephonically nationwide. Actually, I appeared at an interview in New York, in Florida, in Texas, all around really, and it's been wonderful. It's what USCIS kind of is preferring, at least the local ones that we have a close relationship with, because they want to limit the amount of bodies that are in the offices, primarily because the officers themselves are afraid to be in close contact with the public. Who is the public? Me, you, immigrant, applicant. So it's been great that USCIS has allotted and permitted these telephonic appearances. I don't know how long they will continue to allow this for, but hopefully, I don't know, forever. Wouldn't that be nice? There has been several proclamations that have functioned as a visa ban that has since been lifted, which is fantastic. But the travel restrictions that exist are still in place by presidential proclamation. So if you're from the Schengen area, from Brazil, from China, I think from India now too, you can't enter the United States directly. You either have to have a national interest exception to be able to come in straight from that country, like let's say from London straight into the United States, or you got to take a prolonged vacation out to like Mexico, Turkey, Romania is a good one as well, where a country that's going to let you quarantine for 14, 15 days and then enter the United States. And then in addition to that, consulates have just overall been basically closed or operating on very, very minimal capacity because, again, these officers don't want to be in close proximity with the public, which I frankly can't blame them for. But it's hard because cases are not being scheduled for interview, which means cases cannot be approved and people can't move on with their lives. Some consulates, and for some reason, from specific reasons, are permitting expedited appointments. But again, it has to be approved under the national interest exceptions, which is hard to do. Have we done it? Yes. Will we continue to do it? Yes. Is it difficult? Yes, but it can be done. And then COVID tests are required to enter the country. You have to either present a negative COVID test that was taken within the last 3 days before you travel by air into the United States, or if you test positive, you have to get a note from your doctor that shows, although you have tested positive, you are not contagious, or you're not going to add to the spread of COVID-19. So again, super unprecedented times. Can we work around it? Yeah, we absolutely can. But you kind of we just gotta work together to educate you. The June Visa Bulletin, it is out, and it is giving us some additional information about who can apply for or who's eligible to get their green cards at this current moment. What's really most important for us really is this F2A category. The F2A category are when green cards are available to lawful permanent resident those who are applicants who are married to lawful permanent residents. Historically, the F2A category has been backlogged about 2.5 years. For the past, it'll be actually 2 years in August, there has been no backlog with the F2A category, which is awesome and fantastic because ultimately that means that those who are married to a lawful permanent resident, they can come to the United States as soon as their case goes through the full through the lifespan or just the process of getting your green card. There's no additional 2.5 year wait period of waiting until it's your turn in line to get your green card. So that's pretty exciting. From what we understand with the Department of State that issues these visa bulletins is that the F2A category will remain current, or at least will not backlog, or retrogress rather is the correct term. I apologize. Retrogress, and for the next fiscal year. Fiscal year is up in September, so that's good news. So if you fell, or could potentially somebody else that you know could fall under the F2A category, it's good news for them. These are the dates for filing. Again, under the Visa Bulletin, there's going back Visa Bulletin A and then Visa Bulletin B. Visa Bulletin B means somebody who has filed an application during these dates in these given countries can qualify to file their applications with USCIS or with the government, the National Visa Center at the specific time. And then those under Visa Bulletin A, there's a green card ready for them. So that's pretty exciting. And the moment we've all been waiting for, what is a conditional green card? An individual will get a conditional green card, an applicant will get a conditional green card if their green card is issued or approved based off of marriage prior to their 2-year wedding anniversary. So let's say I get married, I get my green card within a year of being married. Well, I'm going to get a conditional green card, meaning it's valid for 2 years. And then as we're getting close to the expiration of that 2-year green card, I have to file an additional application to remove the conditions of my green card. So going through the bullet points, so somebody who gets it based off of marriage and their marriage has not yet met their 2-year wedding anniversary, the conditional green card is valid for 2 years when that green card is issued. And then when that perfect window, the window to file your condition, the removal of conditions is 90 days before the green card expires up until the date of expiration. Now it's critical, it's important to file this green card as soon as you can, once that window opens, because of the delays, the inevitable delays because of COVID, or just through regular USCIS processing of getting a receipt notice. Now it's getting the receipt notice. I guess I should have put this in the information. But getting a receipt notice for an I-751, that removal of conditions application, is really, really important. Receipt notices for the initial application, yeah, cool, they're important. You want to keep them for your records to show that your case has been, what your case was filed, that the case has been received. But for a conditional green card, there's specific wording on the receipt notice that you get, the I-751 receipt notice, that says this individual's conditional green card status has been extended for an additional 18 months. So do you think that your green card your conditional green card is going to be extended or approved and adjudicated fully within those 90 days? Absolutely not. We're talking about the US government. Bless their hearts, but they are slow. And that's okay. They have a lot going on. That receipt notice is critical because while the removal of conditions process may take upwards of 18 months, average it's about 12 to 18 months, we want to make sure that you can still prove that you're a conditional resident. So with that expired conditional green card and your new receipt notice that says, hey, this person's status has been extended for 18 months, you can prove you're still eligible to work, you can extend your driver's license, you can even travel internationally. So scary to travel with an expired green card, right? Nope, not if you have that receipt notice and of course a valid passport to travel with. But with all of that, should be fine. So going back to why is it important to file at the start of that 90-day window? Well, because it's going to take some time for you to get that receipt notice. The sooner you get that receipt notice, the sooner that kind of that Damocles sword that's hanging over your head of what if I need to travel urgently, I need to travel. What if I urgently have to prove to my employer that I have this extended status? Then this is what we have to do. And that's why the sooner you file, the sooner you're going to get that receipt notice. And then what happens if you miss the expiration of your green card? Don't do that. This is why it's really, really important to keep track of your expirations. And if you are a client of ours and we did your initial green card, we will very, very closely monitor and ping you, hey, your status is expired, your conditional green card is expiring. We have to start thinking about the removal of conditions. If you file your I-751 removal of conditions after your conditional green card already expired, you better have a reason as to what happened that you didn't file this removal of conditions, because even the government will send you a notice, usually about like 6 months before. They'll send you a notice saying, hey, your conditional status is expiring. Don't forget to file that removal of conditions. So critical to do that. And in order to get that notice, that reminder from the government, or even a reminder from your attorney's office, you have to make sure to always update your address with USCIS. Make sure that your attorney that you're working with knows where you're living. Updating your address with USCIS by filing Form AR11, either the physical filing or doing it online. USCIS, you're required to do that. You have to let USCIS know within 10 days of a move where you're going up until you become a citizen. You got to let them know where you're living. But we have to let them know so that we can get their notices. So don't forget to change your address as well. So going on some more, who's eligible to file for their I-751 removal of conditions? Well, obviously you have to be a conditional green card holder. If you have a 10-year green card, thank you for joining me on this webinar, but you can log off. Just kidding, don't log off. You can still learn. If you have a 2-year conditional green card based off of marriage, you have to file this. You're eligible and you have to file this removal of conditions. You got your green card based off of marriage. Again, I-751 is for removing your conditions based off of marriage. Do not file this form if you want to remove the conditions for the EB5 category. That's the wrong form. There's a completely separate form for that. And of course, you have to file within that 90-day window before your conditional green card expires. So kind of just pointing to this portion right here, if you are a child and you got your green card, you get a conditional green card based off of your biological parents' marriage. You too are actually responsible for filing for the removal of conditions as well. So it's not just the spouse that has to do it. If the child got it based off of a marriage as well, then you also have to file that removal of conditions. And so there's a couple of different ways that a removal of conditions can be filed. Not all marriages end in a happily ever after. Some marriages end in divorce. But let's focus on the ones that are going to, at least for now, end in that happily ever after. So if you are still happily married, you will be filing the I-751, that removal of conditions application, jointly with your spouse, meaning the both of you, husband and wife and wife, husband and husband, doesn't matter. The two of you are going to be filing, you're both going to be signing this application. And what you're doing is essentially you're proving that you are still in this good faith relationship. Hey, USCIS, I got my green card based off of marriage to my lovely spouse. My spouse and I are still married. We're still in it to win it. And here's proof that we're still in this good faith relationship. You remember all of those good faith marriage documents you filed in that initial green card application? Remember when your attorney said, continue collecting those documents? This is why you're continuing to collect those documents. You want to show the government, hey, these are updates of the documents that we submitted to show you we still have this joint bank account together. Here's our statements that prove that we are actively using that bank account. Oh, here's our lease. Oh, check it out. We have a house now. Even better, look, we're pregnant, or we just had a baby. The best proof of evidence. Should you have kids for immigration purposes? Absolutely not. Have a kid when you're ready. But man, is that a good piece of evidence to show that you're still in a good faith relationship. So with that, we just want to show USCIS any type of document that shows that you're in a good faith relationship. So updates of documents that you submitted when you were initially filed for that green card, plus anything new that you may have. And that the last bullet point, you may be required to attend an interview. So let me expand on that a little bit. USCIS has the ability to either interview you. Hold on, let me take a step back. There's 4 ways that the I-751 application, 4 like pathways that the application could go down. One is the case can be approved right off of the bat. Who falls under the category of those who can have their cases approved right off of the bat? Those who are still in a good faith relationship and they've submitted sufficient documents to the adjudicator, so USCIS officers, liking that the officer can feel, yes, they are totally still married. And B, that they have already gone to an interview locally here in the United States. So if you went through the adjustment of status pathway to get your green card and you attended an interview in the United States on your green card application, you could potentially have your green card interview waived, and the conditional portion of the green card waived. You won't have to have a second interview. If you went through the consular processing pathway and you got your green card in your home country, unfortunately, USCIS wants to see the 2 of you together. They want to see that you're being interviewed here in the United States. So that's where that may be scheduled for interview could happen. So maybe your case could be scheduled for interview. Maybe it could be scheduled for interview. Maybe it could be approved right off of the bat, no questions asked. You filed such a strong application that they don't even have any questions. They know that you're still married. Or they could send you a request for evidence saying, hey, I feel that maybe you're still in a good faith relationship, but come on down. Let's chat. Let's still interview you. Or let's send you the request for evidence. They want some additional information, and then from there they can approve the case, and then they could also choose to RFE you, send you a request for evidence, and schedule you for interview as well. So there's kind of different variations. But again, if you filed for an adjustment of status and you submit sufficient documents to the government's liking that you're still in this good faith relationship, maybe your interview will be waived. If you went through the consular processing route, then you're going to be scheduled for interview. Now, what about those who, unfortunately, their marriage ended or their things aren't going great? You can apply for a removal of conditions with with a waiver, meaning, hey, I got my green card based off of marriage. I was so happy and in love when we first entered our marriage, but it didn't work out, and we had to separate. As long as you can prove that you entered that marriage into good faith and you have at least started the divorce process, then you can still get the removal of conditions approved. You just have some additional documents that you have to present to prove that your marriage was entered into good faith. You can also apply for a waiver if your spouse passed away, which is awfully sad. But so if you got your green card based off of marriage and your spouse passed away, you can still have to prove that your marriage was initially entered in good faith. But we can also prove that your spouse has passed away by providing a death certificate. You can get that removed, the conditions removed. And if you are the victim of domestic violence by that U.S. citizen spouse or LPR spouse, lawful permanent resident spouse that you got your green card based off of, if you can prove that, then you can also get the conditions removed. Maybe you haven't started the divorce process yet, but if you're the victim of abuse, then we can still get that the conditions removed. Or this very last one, termination of my status and removal from the United States would result in extreme hardship. So usually, if we're doing a waiver, we will always mark this portion as well, that it would be an extreme hardship if I entered my marriage in good faith, I've started my life here, we got a divorce, please accept my case this way, plus it would be an extreme hardship if I had to leave the United States. So with that, of course, proving that if I had to go back to my home country, it would be an extreme hardship. So a lot of that is of course, what can we do to prove to the adjudicator's satisfaction that you should continue to maintain your status. Beyond green cards. So what do we have to do to continue to get that becoming a U.S. citizen? So interestingly enough, again, the 751 is not going to be adjudicated very quickly. Earliest that it can be done is, realistically speaking, about a year. Most of the time it takes about 18 months. But if you are married to a United States citizen and have met the 3-year anniversary of having your green card, you can actually apply to become a U.S. citizen before your conditional green card has been lifted and you get that full 10-year green card. Meaning, while your I-751 is still pending, if you meet the eligibility requirements to file for U.S. citizenship, then, hey, you can apply at the same time for your N-400. So again, 2-year anniversary of having your green card, you apply for removal of conditions. 3-year anniversary of having your green card, if, of course, you're married to a U.S. citizen and you have been married to that U.S. citizen spouse for at least 3 years, you qualify for naturalization as well. What we understand from local offices, the USCIS offices, is that if your 751 is still pending and your N-400 is filed, oftentimes it speeds up the processing of your I-751, and both the I-751 and the N-400 naturalization application can be adjudicated at the same time, which is pretty neat. So if you fall under that category, that criteria, which we'll talk more specifics about in a second, then you can apply for U.S. citizenship in 3 years instead of in 5 years. Now, Anita, what happens if I'm doing my removal of conditions with a waiver because I'm getting a divorce? Unfortunately, you're going to have to wait 2 additional years in order for you to qualify for U.S. citizenship. So in 5 years instead of the 3, because again, you have to be married to a United States citizen in order to qualify for 3 years. Now, additional requirements for U.S. citizenship: you have to prove that you've been physically present in the United States for 50% of the time in the U.S., so either a 1.5 years or 2.5 years, depending on the 3 or 5 year eligibility, and you can't have any unexcused absences outside of the United States for more than 6 months. So if you have any trips outside of the U.S. for more than 6 months, you have to talk to and work with an attorney to determine whether or not you still qualify for U.S. citizenship within that 3 or 5 year statutory period. If not, you may have to wait a little bit longer. You have to be a person of good moral character, and you will be interviewed. You will get some civics tests, English reading and writing tests, and then ultimately you will do the oath of allegiance, where you will swear to a couple of things, but swear to be a U.S. citizen, essentially. So N-400 eligibility. So in order to qualify for U.S. citizenship, based off of the 3-year criteria, is you have to be a lawful permanent resident for at least 3 years. You have to be married to and living with a U.S. citizen spouse for at least 3 years. And you have to have been, so you have to, it's 3. You've been a U.S. LPR for 3 years. You're married to a U.S. citizen for 3 years, and you have been living with that U.S. citizen spouse for those full 3 years. So that's what is critical and important. If one of those 3 is not true, you do not qualify in 3 years. You will either have to wait until you qualify, or you will have to wait the full 5 years. So again, if you're doing the I-751 jointly and you've been married for 3 years, which realistically speaking, you're going to have been married for 3 years, then absolutely file. And you can qualify. If you're doing it with a waiver because you're getting a divorce, you'll have to wait until you've been married for 5 years. Going on now, moving on to the next, just kind of talking a little bit about what immigration is looking like under the Biden administration, bringing a close to the conditional residence or the removal of conditions. If you have any questions about anything that I've just gone through today, please go through and ask any questions in the Q&A. So Biden has a 6-pillared immigration plan, where basically this is what he has said that he's going to do over the course of the next 4 years of him being in office, he plans to undo Trump's changes, which he's stuck to his word, and some things have already been changed. Modernizing the immigration system. He wants to welcome immigrants, so no more. So he wants to just be an immigrant-friendly country. He wants to support asylum seekers and refugees, support people to have safety in Central and Latin America, and just implementing an effective border screening. So this is the 6-pillared immigration plan. What has he done since he came into office already? Well, he ended the Muslim ban, which is one of the very first things that he did when he came into office. He's been working on some changes just with deportation to protect children. Just in general, that has been an ongoing problem for the past several years. He has pulled funds from creating the border at the wall, the wall at the border between U.S. and Mexico, and he has already worked on strengthening programs for refugees and for asylum seekers, which is fantastic. And he has replaced Buy American, Hire American. So again, really going back to being a more immigrant-friendly country. There are some proposals that Biden has already been working on while he's been in office. One of them is the U.S. Citizenship Act of 2021. And what is that? Oh, sorry. What does that mean? This is really kind of just really going towards those working towards those 6 pillars. So what can we do to provide a pathway for U.S. citizenship for those who are undocumented? What can we do to just better our immigration system in its entirety? Our immigration system is quite archaic. So going through this is fantastic. There's currently 2 bills. There's one in House, there's one in Senate, and they're both providing hope, providing a more immigrant-friendly, no more anti-immigrant USA is really what we're focusing on. So here are some of the highlights from those. There's several proposals, there are several bills that are currently in play. So providing more working visas, clearing green card backlogs and reducing the lengthy priority date wait times and eliminate per country caps. So that visa bulletin that you looked at, we were looking at the family-based visa bulletin that has the specifics of several countries. Well, there's an employment-based track of that as well, and they're backlogged. It's archaic. Having limits on who from India, China, Vietnam, the Philippines can enter the United States, that's strange. We don't need that anymore. So just working towards that. Providing a new green card pathway for advanced STEM grads from U.S. universities. So just more pathways of getting status or getting green cards and then eventually U.S. citizenship for people in the U.S. Making H-4 EADs permanent. H-4, so those who are on H-1Bs, their spouses or their dependents get H-4 visas, and they're for whatever reason their employment authorization is always on the chopping block for whatever reason. I don't know why. They're a dependent in the U.S. and they're just expected to come here and just be a stay-at-home spouse, and that's just not realistic. So making that permanent for them. Preventing children from aging out, which is huge for the family-based categories. Under the F4 sibling category, there's children that age out so often because the category is backlogged by 15 to 20 years, 20 plus years for people from Mexico, for example. So if, like, for example, I got my green card based off of my dad's brother who petitioned for us. So we came through the sibling category. If we applied now, or we applied at a time that I would not be able to get my green card before I was 21 years old, I would not be able to benefit from getting my green card, and I wouldn't be able to come to the United States with my family. So that's a huge portion of it as well. So I love this idea. And then just new regional economic development green cards. So if you want to come and you want to live in a very sparsely populated region in the United States, we'll give you a green card. Come join us. So why not? Keeping families together, it would allow for beneficiaries with approved I-130 visa petitions to enter the United States while they're waiting for their priority dates to become current. So again, think the F4 visa category where there's a backlog of 15, 20 plus years. This would be fantastic to be able to have an approved I-130 and come and start your life in the United States already. Why not? Eliminating the 3 and 10-year bars. If you're in the United States and have overstayed a visa or have accrued unlawful presence, you could have the 3 or 10-year bars against you, meaning you can't enter the United States for 3 or 10 years. So getting rid of that, making it easier for spouses and children to join their families already in the United States, speeding up processing times by increasing the number of green cards and available and recapturing unused green cards, which would be fantastic. Increasing the number of green cards in the diversity lottery, which would be super cool. The diversity lottery is wonderful and so many people can benefit from it. So why not increase the number of that? And then stop using the word alien and change it to non-citizen. That's already, it's already happening and it's already in place, which is awesome. So if you remember when you looked at my green card earlier, I was a resident alien and I was little Anita was so offended that she was an alien and she just didn't get why. But yeah, so now I would have been considered a non-citizen, not an alien. And then pathways to citizenship. So this is what I was talking about, that the undocumented individuals who are in the U.S. either with DACA or just don't have status at all have potential pathways to U.S. citizenship, which is the coolest thing, if you ask me. These individuals have been in the United States and have been productive members of society. Let's reward them. Let's give them the ability to become green card holders and become U.S. citizens. Why not? They deserve it. And then so this is the DREAM Act, which they're the 2 bills that I was mentioning earlier that are one is with House, one is with Senate. Both of them give this pathway to citizenship, and it's a 3-step pathway. First, you get a conditional permanent, you get a conditional green card as well, and then you become an official permanent resident, and then eventually you can apply for citizenship. The pathway is a long one. I think it's 10 plus years, but it's a pathway. So these people who have been in the United States can finally come out of the shadows and they can live comfortably live their American dreams. So this is just some more information on the House bill versus the Senate bill. You guys are going to get these slides so you can take a look at them more closely, but it just kind of breaks down what the difference between the House and the Senate bill is and what the different requirements or eligibility requirements for both are. So they're pretty neat. Anyway, I will wrap up and I will allow you all to ask any questions that you may have. Please put in those questions in the Q&A. I'm happy to go through them. Again, this is a public webinar, so any questions that you put in there for me to answer will not be confidential, so please be mindful of what information or questions that you're asking. If you have any additional questions, I'm happy to schedule a consultation with you. This is how you can contact us and how you can be a part of just the Alcorn family. Follow us on LinkedIn, Twitter, Instagram, Facebook. We have a podcast that I'm a frequenter on, so you can go on and there's a new episode every Tuesday. We try to put some family-based topics in there as well. So go in, have a listen, and just reach out to us, be a part of us, and let us know what we can do to support you. Okay, have some questions trickling in. Can my I-751 be denied without an interview? It can. Will it probably happen? I would say probably not. And so just in general with USCIS, once you file a case, unless it's rejected because you forgot to include something or you just did something massively wrong, you're not going to get a denial straight away. You will get a request for evidence or you will get a notice of intent to deny. So will it be denied without an interview? Possibly, but you'll get some sort of understanding or some sort of inkling as to what is going on, that your case is being denied, or that it's imminently going to be denied. If you have any more follow-up questions to that, please send that follow-up in the Q&A. What kind of evidence do I need to file for an I-751? Great question. So essentially, it, of course, first depends on the type of I-751 or removal of conditions that you're filing on. Are you filing it with a waiver, or are you filing it jointly? Either way, regardless of what kind of removal of conditions application that you're going to be filing for, make sure that you're providing good faith marriage documents, whether it's good faith marriage documents presently that still exist that you're continuing to collect because you're filing jointly, or just any kind of good faith marriage documents to establish that when we first entered our relationship, and since I have gotten my green card, these are the additional good faith marriage documents that we had. So maybe you got married, you got your green card 1 year into the relationship, and then after you got your green card, you tried to hang on so tight to that relationship, but after you got the green card, you guys split after 6 months, or you split after 1 year. Well, during that 6 months or 1 year, what documents do you have to establish or to prove that you were still in this good faith relationship? So any good faith marriage documents, anything can work. Photos, bank statements, lease agreements, anything that has both of your names on it together that will show that you're in this good faith relationship. Additional documents, like if you're going through the waiver process because you're getting divorced, well, do you have any documents to prove that you tried to make the relationship work? Did you go to counseling? Did you go what did you do to try to make that relationship work? Because that goes to prove that you were in this good faith relationship, or at least you tried. You entered it with the strong hopes of forever, but unfortunately, that's not reality for absolutely everybody. So anything really to show that you're in a good faith relationship. Now, one piece of evidence that I personally don't include in my applications that I file for my clients are affidavits. I will wait to file an affidavit until and unless USCIS makes me send one in. I'm always very apprehensive of providing affidavits, letters of support. So like getting a letter from mom, dad, cousins, friends, anybody to help corroborate our relationship. I don't like to do that because it just leaves too much room for inconsistency with any testimony that could be provided, that was provided initially during your green card interview, or any documents that you've provided initially and then now with the removal of conditions. It just leaves for too much room for things to get murky. So if I don't need to submit an affidavit, I will not do it. That's my style of practice. If I have a client that comes to me and says, Anita, I want you to include this affidavit, I say, okay, you know the risks of it, and ultimately it's your application. It is just my duty to let you know what my thoughts are and what my style of practice is. So food for thought for all of you out there. If my client comes to me with almost no evidence, like especially if it's a waiver, then I will highly consider doing an affidavit as well, just because every case is different, but for the most part, I won't include an affidavit, but again, food for thought. Thanks for all the information. You're welcome. Thanks for coming. I have a question for the filing citizenship while I-751 is pending. I have been married to a U.S. citizen for more than 3 years, but I haven't been a permanent resident for 3 years yet, counting from when my conditional green card is approved. I can't file for application for citizenship yet, correct? So we don't, it's not on the, now correct me if I'm not answering your question directly, but the 3-year start from when your conditional green card is received. So let's say I got my conditional green card on January the 1st of 2000. On January the 1st of 2002 is when my conditional green card will expire, meaning 90 days before then. So that would be October, September, whatever, one of those dates. The 3 months before is when I will qualify to submit my removal of conditions. And then January the 1st of 2003 is when I will qualify for U.S. citizenship based off of marriage to a U.S. citizen. So if you've met that 3-year anniversary of having your conditional green card, then you qualify for U.S. citizenship. So hold on tight until you've met that 3-year anniversary and then file for U.S. citizenship. Now, let me add in an additional riddle. Let me confuse you a little bit more. Like the I-751 90-day window, citizenship has that same 90-day window. So basically, you will qualify to file your application for U.S. citizenship 90 days before that 3 years anyway. So maybe you're almost there. But if you have any questions or you're just uncertain or unsure, reach out to me and we can support you in kind of really figuring out the dates on when you qualify. I will wait for a couple of more seconds to see if any of you all have any additional questions for me. But otherwise, I will let you all go and you can enjoy the rest of your afternoon or morning. Wonderful. So I don't think I'm getting any additional questions trickling in. Again, if there's anything, absolutely anything I can do to support you or your loved ones in your American journey, your journey towards the American dream, please feel free to reach out to me and my team. We would be absolutely thrilled to be a part of your journey with you. Thank you for being a part of this webinar today, and have a good one. Take care. Bye-bye.